Welcome to EI Legal's video on transfer of business. I'm Hannah Mills, a solicitor here at EI Legal. The scope of the transfer of business rules has been significantly widened under the Fair Work Act. A transfer of business will now occur when the following four factors are met. 1. The employment of an employee of the old employer has terminated. 2. Within 3 months after the termination, the employee becomes employed by the new employer. 3. The work the employee performs for the new employer is substantially the same as the work they performed for the old employer. And 4. Such work transferred in connection with the transfer of assets, an outsourcing or insourcing of work, or a transfer between related companies. So what is the effect of a transfer of business on an industrial instrument? An enterprise agreement, enterprise award, and individual flexibility agreement made under an enterprise agreement or enterprise award will be a transferable instrument under the Fair Work Act. A transferable instrument will continue to apply to transferring employees until it is terminated or replaced. In addition, where an employer employs a new employee to do the transferring work after the transfer of business, and an instrument has transferred as discussed previously, and no enterprise agreement or modern award covers the new employer at the time the new employee is employed, the transferable instrument will also cover the new employees in relation to that work. There are certain orders that Fair Work Australia can make on the application of a new employer, a transferring employee, and in some circumstances, a union. These orders could have a wide range of effects, including that the transferring employees are not covered by the transferable instrument, but are covered by the enterprise agreement or enterprise award that covers the new employer, or that a transferable instrument will cover a non-transferring employee who performs the transferring work. There are a number of factors which Fair Work Australia must consider before making any of these orders, so they will not always be a viable option for new employers, and the circumstances of each case will need to be considered. The Fair Work Act also provides for the transfer of high income guarantees in certain circumstances, so employers should also keep this in mind. So what is the effect of a transfer of business on employee entitlements? There are a number of employee entitlements that need to be considered in a transfer of business, namely personal leave, long service leave, parental leave, annual leave, statutory and contractual redundancy pay, and notice of termination. In the case of a restructure or transfer between associated entities, the new employer must recognise the employee's service for the purposes of all of these entitlements. In a transfer of business between non-associated entities, the new employer must assume the liability for the transferring employee's personal leave, long service leave, and parental leave, and recognise the transferring employee's continuity of services for the purposes of calculating these entitlements. However, the new employer and the old employer are free to commercially agree whether or not annual leave will be paid out by the old employer or assumed by the new employer. There should generally be a reduction in the purchase price where this liability is assumed by the new employer. It's important to remember that annual leave is paid out at the employee's rate of pay when they take the leave, so it is likely to be cheaper to pay out all the accrued annual leave as at the date of completion rather than paying it out at a future time post-completion at a potentially higher rate of pay. The liability for redundancy pay will depend on the circumstances of the particular case. For example, if the new employer does not wish to retain some or all of the old employer's employees, the old employer will be liable for the payment of redundancy pay to those employees, because those employees' positions will no longer be required to be performed by anyone. In transfers between non-associated entities, the new employer can decide not to recognise the employee's service with the old employer for the purposes of redundancy pay. In this case, the transferring employee would be entitled to payment of the appropriate amount of redundancy pay from the old employer. However, in the event that a transferring employee rejects an offer of employment from the new employer on terms that are substantially similar and where continuity of service is recognised, the employee will not be entitled to statutory redundancy pay under the Fair Work Act. Given redundancy pay is a contingent liability and will not arise for those employees that resign, are summarily dismissed, or are terminated on performance grounds, sellers will often be unwilling to adjust the purchase price downwards in respect of this liability. Employers should also review any contracts or company policies which contain entitlements to redundancy pay to confirm whether or not payment is required under either of those in a transfer of business scenario. In relation to notice of termination, it is always advisable for the old employer to give the employees adequate notice of the transfer of business, so that they do not become liable to make payment in lieu of notice. What are the notification requirements of a transfer? Modern awards all contain a consultation provision, which requires that an old employer must consult with employees as soon as a definite decision has been made, which is likely to have a significant effect on employees, such as where employees will be made redundant or will be employed by a new employer. Employers that have enterprise agreements covering their staff should also check their enterprise agreements for any consultation provisions and must ensure that they comply with those. In any event, it is always good management and HR practice to consult with employees as soon as practicable about the nature of the transfer and what it will mean to them. Transfers of business are a complex area of the Fair Work Act, but it is important that employers can identify when a transfer may occur and understand the implication of a transfer of business on instruments and employee entitlements. In cases of a transfer of assets, buyers should always conduct appropriate due diligence of the employment arrangements. Parties involved in a transfer should ensure that the outcome of commercial negotiations with respect to transferring employees and their entitlements are clearly drafted into the commercial agreement, with the appropriate warranties and indemnities given. If you would like more information or need legal advice about transfer of business, please contact us on the details provided. Thank you.